All right, now we are here for State of Ohio versus John Pustelniak. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to do so, let me know before you start your argument. The argument will be recorded. I'll do my best during the course of this to keep you apprised of time. I would tell you not to use any names of victims or children, but that's not an issue in this case, so we don't have to worry about that. We have read your briefs, and we are ready to begin when you are, and I believe this is a state's appeal, so Mr. Murphy, whenever you want to begin.
Thank you. Good morning, Judge Callahan, Judge Schaefer, Judge Teodosio.
Morning.
The trial court during the resentencing hearing was when it imposed an 18-month term of incarceration on the first count of failure to comply, a third-degree felony in this case. At the initial sentencing hearing, the 36-month term that was imposed on that first count of failure to comply was lawfully and properly imposed. Neither party appealed the sentence on that count during the direct appeal and cross appeal. The 36-month sentence, therefore, should have stood at the resentencing hearing. That should have been limited to sentencing on the 2 counts of failure to comply that the trial court incorrectly deemed allied offenses to this first count during that sentencing hearing. Therefore, as it stands now, yes,
Mr.
Judge.
Murphy, I'm sorry to interrupt. Did you want to reserve rebuttal time?
I'm sorry, I'll reserve 3 minutes, Judge. Thank you.
Okay. Sure.
Not used to being in this position.
I know.
So therefore, at this time, the 18-month prison term, as it stands now, is clearly and convincingly contrary to law. The state at the end is going to ask this court reverse the trial court's judgment to resentence on the first count of failure to comply, vacate that sentence, and either remand with specific instructions to impose the 36-month sentence or use this court's authority to simply impose the 36-month sentence, as that's what the trial court must do on remand.
Let me ask you a question, since you said that's what the trial court must do. I understand where you're coming from, and of course I went back and read the first appeal and the ninth decision, and as I read it, correct or not correct or artful or inartful, we said this matter must be remanded for resentencing on his convictions that are felonies of the 3rd degree. How do you get around that if that's what we told the trial judge to do?
Judge, I think that the trial court had to look at that, and obviously the trial court knew what the Saxon case said. It acknowledged Saxon. So it's not the state's position that the trial court disregarded Saxon, but that it misapplied it and maybe disregarded the spirit and intent. In the state's reply brief, the state quotes at length a recent 8th District decision from Grayson, in which the court says, look, sometimes we as appeals courts rely on some very general language, and we don't really look at the particular circumstances of the case in remanding. And what I'd point out is, if the court feels that way, that you do, Judge Callahan, in that it inartfully remanded the case.
I didn't say I felt that way. I just
may have.
Posing a hypothetical to you.
Sure. So hypothetically, if the court wants to look at it that way, I think that we all have to recognize that mistakes are made, and that the court would have to acknowledge that Saxon doesn't allow it to do what the court apparently wrote in the opinion. Saxon doesn't allow for resentencing on all the third-degree felony failure to comply in this case. It only allowed for resentencing on the 2 third-degree felony failure to comply. So the court can't condone not following Supreme Court precedent. And if that takes acknowledging inexact language, perhaps, then that's what the court has to do, because this court can't have out there precedent that disregards Supreme Court precedent, that isn't faithful to that Supreme Court precedent, and frankly isn't consistent with other cases that this court has decided, such as Ross and Hobson, that the state cites in its brief. And the reason that we're not, that this case, I'll jump ahead a little bit here in the argument, but I think procedurally is where this case maybe gets a little confusing, or why it's a little difficult to apply precedent like Saxon and like Ross and like Hobson. Because in this case, what the court did, if you think about it visually, is the court took 2 counts of failure to comply and subsumed them into the 1 count of failure to comply. They merged them, right? The trial court did. So on remand, what this court did was it said, no, merger doesn't apply. Changes here. So what the court did was it pulled those 2 counts back out of third-degree failure to comply. And so now we have a sentence already imposed on the first count of failure to comply. No one appealed that sentence. And when we went back procedurally, there was no discussion to be had about whether those were allied offenses of similar import, the 3 counts of failure to comply. This court already decided that they were not allied offenses. And when we went back, there was no election by the state on any of those counts. The state didn't have to elect on any of them, which is unusual, because in normal circumstances, either on remand, the trial court has to decide if any of the counts are allied offenses, or once the trial court does decide under normal circumstances, then the state has to elect on which count or counts to proceed to sentence on. Or in this case, more normal circumstances, from what the case law shows, on remand, having been told that the counts are allied offenses, the state still has to elect, but here there was no election to be had. So procedurally, we went back to the sentencing hearing, and all that had to be done was to sentence on 2 counts of failure to comply, third-degree felonies, because there was no election to be had, and there was no allied offenses analysis to do. That was all taken care of. So you were just.
I think I get where you're going to on that argument. My question is state versus Christian. Is that applicable to this case? It seems as if it might be, since a portion of this defendant's sentence was vacated.
Right. It's not applicable.
Why not?
Christian deals with, first of all, a count that was vacated, a count on which the sentence was vacated. The Christian case said that the holding was when a portion of the defendant's sentence has been vacated on direct appeal, the trial court had authority to resentence on any counts for which the original sentence was vacated. The original sentence was not or should not have been vacated on the first count of failure to comply in this case. There was no reason to address that case or that count. It didn't need to be fixed. That's what we take away from the Ross case, is don't fix the counts that don't need to be fixed. And what you take away from Hobson too is deal with the legally problematic count or counts or cases for that matter, like Hobson. There were 5 cases in the Hobson case. There was a plea deal that resulted in 8 years, and Hobson raised a constitutional challenge to the failure to register case. The trial court there said, I'm vacating all the sentences in all 5 cases. And this court said, that's wrong. You only vacate despite the plea bargain, which was 5 cases together, you only can vacate the sentence on the failure to register. That's similar here. You're only vacating on the
two merged.
Vacating the judgment that the trial court decided it didn't need to sentence on those 2 counts. Judge, I'd actually point out that Christian is probably more favorable to the state, because in that case, in Christian, the court said you can go back, trial court, and resentence on the counts for which the original sentence was vacated. It didn't say go back and do a resentencing. Of course, 1 count's wrong, you go back and you resentence. So actually, the authority there, what you could take away from that case relevant to this case, is that you don't go back and deal with counts that were fine at the original sentence. There was nothing to fix. And frankly, in Christian, the procedural posture of that case is really bizarre. The defendant had served a prison term. House Bill 86 had decreased the potential penalties on certain counts because it decreased their felony levels. So it's a very strange procedural posture. It's unusual. It's not something that's probably going to arise a whole lot. But the only count that what that case says is go back trial court and deal with the sentences that were vacated. But if they weren't vacated, don't do anything with them. Leave them alone. That's what the state's saying. So frankly, this case is that Christian case probably supports the state's position more in this case, not Mr. Pustelniak's. Yes, Judge Callahan.
No, I'm good.
Okay. But the 2 critical facts to remember here, I think, are that no one on direct or cross appeal appealed the sentence on count 1. No one appealed it. The moment no one appealed it, and Judge Teodosi, this kind of goes toward that Christian case, is the finality was achieved in that case, on that first count. There was finality on that count the moment no one appealed the sentence that was imposed. The state appealed the fact that the trial court failed to impose the sentence. That's on 2 counts. That's been the state's position from the beginning. In fact, the state.
Just so you know, you're in your rebuttal time.
Thank you, Judge. I'm going to keep going for a minute here. The state cited Ross in the conclusion of its brief, cross appeal brief. The state cited Ross and specifically said, this was our position all along. And that shows that this was our position all along, unlike what Mr. Pustelniak asserts in his brief. It was the state's position in the resentencing memorandum. It was the state's position in the resentencing hearing. The other critical, the error that the state cited and that this court sustained was the trial court's judgment not to impose sentence on 2 counts. And when it didn't impose those sentences, when that's the error, the remedy is to go back and to impose those sentences. I'll reserve the rest of my time. Thank you.
Thank you.
Okay. Ms. Bremke, whenever you're ready.
Yes, Your Honors. Giovanna Bremke on behalf of Mr. Pustelniak. I think it's important to note, coming off of the state's argument, is that none of these cases that are cited were brought by the state. So when you're talking Ross, Saxon, all the cases that were cited. And I think that's important to note because the nature and the intent of these cases is as a safeguard for the defendant, that the defendant doesn't receive an increased sentence or a harsher penalty as a result of a remand from the trial court, as, you know, sort of like an appellate tax almost. You know, we've heard of trial tax, but almost like an appellate tax that because it's been remanded, you know, you can reopen all of these different counts and sentence an increased sentence. And that's just not the case. And, you know, what the intent really is that these merger, the merger, the 3 counts that were merged would give a sentence that is proportionate to the conduct that Mr. Pustelniak exhibited. So what the trial court did is gave a fair and proportionate sentence, and also in following this court's order. So
let me ask you a question about that.
sure.
Isn't that basically what Saxon prohibits? Isn't that the same thing as bundling? And you know, again, I think it might be the dissent in Saxon that says, you know, welcome to the real world. That's what plea negotiations, that's what sentencing is. But Saxon's still Saxon. Isn't it actually bundling? There was a sentence, overall sentence, the trial court wanted and got back to it this way. How is that not bundling?
Yeah, I think, again, you know, it's different because, you know, this is a state appeal, and the ultimately the factors of sentencing are whether it's fair and in proportionate to the conduct. And so, again, it's, you know, it's different because the state is bringing this appeal saying, hey, you've got to give 3 times the amount, which that's not a fair sentence. And that's what the trial court had concluded. You know, the state also says, you know, argues that they had not appealed the first count, which is just, you know, it's not something that's consistent with the prior appeal. So, you know, in the opening line of their March 26, 2019 brief, it says the state's appeal is limited to the 3 third-degree failure to comply counts. Again, that's, and now the argument is that it didn't appeal that first count. Additionally, at the resentencing hearing, and you can find it on the transcript, page 11, again, what the state is saying is that the Court of Appeals found that the court was wrong in merging the 3 F3 failure to comply counts and remanding the case for resentencing as to those counts, meaning those 3 counts. And then again, as Judge Callahan mentioned, this court's order in remanding is something also that the trial court relied on. And that's in the transcript, page 16 and 17. The trial court actually reads back the language in which this court says that it's remanding for resentencing as to his convictions under section 2921.331B, which are felonies of the 3rd degree. And what we know is there's 3 of those. So it's the court's definitely within their discretion to resentence as to those 3. One, the state did argue it, and they argued for you know, the 3 counts, and also this court ordered that it do that. So the state was certainly, or the judge, I'm sorry, was certainly within his discretion to resentence as to those 3 counts.
Counsel, can I ask you a question? And I've tried to discern this. It appears that count 1 was originally, 36 months, is that correct?
Yes.
And then it was resentenced down to 18 months. What happened to the other, what was the sentence on the other 2 willful fleeing charges? Because of all the renumbering, I could not figure it out.
You mean on count 2 and 3?
Right.
Yes.
Okay, I think that this is on my, on the 8th and 9th page of my brief here. And it was 9 counts on count 2. 9 months, I'm sorry, I said 9 counts. 9 months.
I knew what you meant.
On count 2. And I have here that it was, count 3 was merged, but I don't know that that's accurate.
Unfortunately, that's what I'm seeing, and I don't understand that. That's what threw me off. 2 things threw me off. First thing is, were these now all consecutive, or was anything run concurrent on the willful fleeing? And the other thing is, on that count 3 merged, that's what I'm seeing, and I don't get how. But that's just something. I don't want to take up your argument time over that issue.
Sure.
I just was hoping you could shed some light for me.
Yeah, I'm seeing that as well. There's 18 on count 1, 9 on count 2, and no sentence on count 3. But again, I'd have to go back and look at that. I also did, as Judge Teodosio had mentioned, I filed the notice of supplemental authority because this Christian case came out just very recently after I'd filed the brief. It was just decided in 2020. And again, what Christian stands for, and I think it's important to look at Christian because, again, they're looking at it from the defendant's perspective and the expectation of finality. And here they're saying, you know, there isn't this expectation of finality until the appellate process has run. And again, with the state, in the opening sentence says, we're appealing these 3 counts. How would Mr. Pustelniak have this expectation of finality in his sentence, given the fact that the state has repeatedly argued that the 3 that they are appealing those 3 failure to comply counts. And again, even at the resentencing in which Mr. Pustelniak was present, he was transported from the prison. The argument was by the prosecutor at that point that we need to resentence on these 3 counts. So the Christian, again, stands for the fact that when we're looking at it, we're looking at expectation of finality. And they're looking at it from a defendant's perspective. I don't know if that can also interpret to the state's perspective if they had an expectation of finality. But the fact is that the appellate process hadn't run. So there wasn't an expectation of finality in the sentence. And I think that's also clear by this court's order saying, you know, resentence on the F3 counts under that section, and count 1 is definitely included in that. Any other questions? No?
Doesn't look like there are.
So we would have just asked that you affirm the court's decision. Again, it's consistent with what the state has argued. It's consistent with what this court remanded for the, for the judge to do. And he actually had cited that sentence from this court when he did resentence. Thank you.
All right, thank you. Mr. Murphy, whenever you're ready. Got a minute and 43 seconds.
Thanks, Judge. With regard to appealing the first count, that statement was made with regard to the allied offenses of similar import analysis. But when you look at the state's assignment of error, it essentially boils down to failing to impose sentences on 2 charges was clearly and convincingly contrary to law. That's a sentencing appeals framing right there, a sentence. The count 1 only factored into we weren't saying that the grand theft motor vehicle, for instance, merged. We weren't raising an issue there. Judge, real quickly, the willful fleeing was a minor misdemeanor, and this after the initial attempt to appeal, that was merged into the failure to comply. And then a second direct appeal was filed. Judges, I'd point this out. If you decide for Mr. Pustelniak here, then Mr. Pustelniak on remand could be sentenced. If he were initially sentenced to 18 months, the judge could resentence to 36 months. It's a de novo sentencing. This is not a vindictiveness in sentencing opinion, Saxon. Saxon compels the conclusion that a resentencing on the first degree of failure to comply, felony 3, was incorrect. Therefore, it needs to be reversed. That sentence needs to be vacated, and the 36 months needs to be reimposed. This isn't a fairness, it's not a proportionality argument here. It's a simple legal argument that that's what Saxon stands for. We don't fix what doesn't need to be fixed.
Well, it's your position that Saxon compels resentencing on the wrongly merged counts only.
Saxon compels resentencing on the wrongly merged counts only. That's correct, Judge Schaefer. Correct.
Okay. All right. Any other questions from anyone?
Thank
All
you.
right. Thank you both for your arguments. We will take the matter under advisement. We'll issue a written decision in due course. It'll be mailed to both sides as well as posted on our website and on the Supreme Court website.